because anything is possible. So that's good to know. All right, so a lot of people out there who are considering going through a bankruptcy, one of the things that's scary is, well, they put their money to the side. Maybe they've got some savings, or they've got some cash put away, they've got different assets, 401k, IRA. If you go through a bankruptcy, what happens to their savings? What can happen?
That's a good question, because you will have lots of people coming into the office who have done just that. They put money aside in order to be able just to live, and they anticipate that the courts will allow them to keep that because they need that money to live. Well, that's not the way it works. When you're dealing with an experienced bankruptcy attorney, there are a lot of things you can do to protect that money. Money in your checking account, or your savings account, or in the fridge drawer, or under the bed. Okay? Timing is very important. You don't want to file when that money is accessible and available to the trustee. The trustee is the person who represents the government in bankruptcy proceedings. So timing is very important. But when you reference the IRAs, the 401s, the pensions, those are accounts that are exempt, meaning they're not available to be taken by creditors or by the trustee.
So if someone has, so if you have money and you have put aside and it's some sort of retirement account, right? 401k, or again, you're going to want to sit down with a bankruptcy attorney. If you're in the state of Florida and South Florida, you're certainly going to want to talk to Richard Gilbert. But you want to make sure that the money you have put aside that's going to be protected are retirement accounts.
Let me add to that. The trustee is not foolish. You can't suddenly take this money that has been under your bed or in your checking account and put it into an IRA or a 401 all of a sudden. That's the one thing you can't do. So that's why you need to talk to somebody who knows what you can do and what you can't do. And I may add this, what has happened in the last 6 or 8 months, or more than that, 2 years even, as real estate, for example, become a less lucrative field of law, and other fields of law that had been lucrative are no longer lucrative. Many of these lawyers are saying, hey, I think I'll do bankruptcy. That may be a popular type of practice to get into. And as a result, they get into bankruptcy, and they make efforts to file bankruptcies. And if you don't know what you're doing, just the smallest error can be almost fatal to the consumer. And I've seen instances, which I can share with you.
Sure, give an example if you would.
Okay. As an individual, if you're going to file bankruptcy, you do not need to be joined by your spouse. Sometimes you should be, and that's the termination of implementing the office, but you don't have to be joined by your spouse. I was at a 341 meeting, which is basically a meeting of creditors, which is named after the section of the bankruptcy code that provides for it, section 341. And at these meetings, creditors had the opportunity to ask questions of the debtor. They don't usually show up, by the way. They're not there very often. They have a right to be there. But at one of the recent meetings, I witnessed a woman who had filed without her husband with a brand new bankruptcy attorney. And she filed individually, like I said, which is certainly permissible. And she had a lot of debt. How? I don't know. I wasn't part of the filing. And very, very little income. So as an individual, she was a great candidate for a Chapter 7. What she failed to know was that even in individual filings, the income of your spouse has to be taken into consideration. He doesn't have to file, or she doesn't have to file, but his or her income is taken into consideration. So this woman who may have made a minimal income had to disclose that her husband made a tremendous income. So now, as a result, you join their incomes together, and you take away their expenses from that income, there is an abundance of leftover money. That leftover money has to go to pay the creditors. So this woman, who was trying to do a 7 to get out from under the debt that was in her name, now may have been hers and her husband's debt that was in her name, was forced by the court to do what we just mentioned. She had to convert to a 13. And in a 13, you are forced to pay back some money to your creditor. It doesn't have to be much. It can be as little as $5 a month or less to your unsecured creditors, those who have no collateral, but you have to pay back something. And because you have a lot of money left over, and a lot of debt, you make your payment every month, and that's phenomenal payment to these unsecured creditors. And a lawyer who has been doing bankruptcy for a long time would have known this. And there are certain adjustments that could have been made that were not made.
So rule of thumb is, and there have been people that I understand that, listen, everyone wants a good deal, right? But when you're dealing with something with bankruptcy, such a sensitive issue, when you're dealing with something that involves so much of your life, it's important to select someone who is credible, who's an expert or has done a lot of what you need them to do. Don't go with the cheapest one. It's the same reason you don't want to go with the cheapest bankruptcy attorney, the same reason you wouldn't want to go with the cheapest surgeon who's getting ready to perform heart surgery. Because it's not about, hey, I need the best price for my heart surgery. It's, I want the best. So I encourage you to make sure that when you are interviewing attorneys, if you're outside of the state of Florida and you're going to be looking at other attorneys, to make sure you understand their background, how long they've been doing bankruptcy cases, and it's a very important part. So thank you for bringing that up.